I presume your attorney has spoken to you about whether or not you can be held in contempt and explain what consecutive sentences are?
Yes, ma'am, I'm fully aware. I don't mean to disrespect. I don't mean to, if you even get a hint that I'm being disrespectful to your honor, just wave your finger at me like a naughty boy and I'll stop.
Good afternoon. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. Court will call the case of the State of Michigan versus Jeffrey Bloom, case number 21-S00829.
Good afternoon, Your Honor. Laura Willenbring on behalf of the people.
I'm sorry, Your Honor, I was muted. Robert J. Kilwald on behalf of Jeffrey Bloom. Jeffrey, would you state your name for the record?
Jeffrey Bloom.
Good afternoon, everyone.
Good afternoon.
Your Honor, this is my motion, Your Honor, and I'm assuming the court has read my motion. And I just want to first state, Your Honor, this is my motion to allow Mr. Bloom to withdraw his plea. And I want to just state for the record, I'm not here to embarrass Mr. Banas in this case, but I would strongly argue that the fact that in this matter, the fact that he was also representing a Miss Blaisdell was a fatal flaw in my client's case, and I think the court should look strongly at setting aside his plea. I know he pled no contest. I've read the transcript, but again, Your Honor, the fact that Miss Blaisdell was not called, and I understand the prosecutor makes in her argument that, well, she wasn't considered by the prosecutor and she wasn't considered by the defense. But the fact of it is, Your Honor, she was not even investigated by Mr. Banas. The fact that the police report says she says one thing is not an investigation that he should have taken to talk to Miss Blaisdell. Because the fact of it is, Your Honor, it's easy to say one thing on the police report, but it's another thing to say under oath that we believe she would have admitted she was there. She had witnessed the whole incident, whereby she would admit that Jeffrey did not do half the things he was accused of, Your Honor. And I don't think it's any jeopardy to the prosecutor because, one, it's my understanding Miss Blaisdell is in jail and Jeffrey's mother lives just around the corner from the courthouse. So again, Your Honor, I don't think any prejudice is shown by the prosecutor, Your Honor, if you would allow my client to withdraw his plea. There's other matters in my motion. I said that interns visited my client instead of Mr. Banas. I believe what my client tells me, but again, the critical issue, Your Honor, is there was a Ray Just eyewitness that was not even considered, whether it was by the prosecutor, that doesn't concern me, but it should have been considered by the Mr. Banas, and it should have been investigated to properly find out what exactly she knew. And you just can't go by the police report, Your Honor. It should have been investigated further because, again, I don't want to sound like a broken record, but we believe.
Well, at this point, you've repeated that like 3 times.
Well, Your Honor, that's my issue, though. I mean, that is the whole issue in this matter. A witness was not presented that could have been presented that may have turned this matter around had my client gone to trial.
That's not everything.
Jeffrey?
Kilowell.
Your Honor.
Mr. Kilowell.
Yes, Your Honor.
Did you have an opportunity to review the transcript?
Because I did, Your Honor.
The issue is whether or not he's been properly advised of his rights. And are you raising any challenges to that?
Well, Your Honor, I read the transcript. I met with Jeffrey last night. We sat around. Well, we didn't sit around. For an hour and a half, we threw things around. But the fact of it is, Your Honor, how could he get good advice?
Mr. Kilowell.
Yes, Your Honor.
My question was, is there any challenge to his advice of rights?
No, Your Honor, other than that had there been an investigation of the witness, he wouldn't have pled, Your Honor, no.
So my understanding is that we addressed those issues that you just brought up last time. And when we had this argument, you began those arguments at that time. And based on those arguments, we decided to set today for what's called a Ginther hearing. And so The court is very aware of what the arguments are with respect to that. So the only question I had before you started arguing the same points again, was whether or not you wanted to hold against the hearing today.
Your Honor, if I can make one comment regarding the transcript. On page 30, Your Honor said, I'm not asking you on lines 7 through 9. I'm not asking you not to love your mother. And if your love is pushing your mother onto the couch and grabbing her by the face, Your Honor, again, with all due respect, Your Honor, that was never conceded to, Your Honor. And I think Your Honor should have not spoken to that. Even though my client denied it, I think it was inappropriate for Your Honor to state that on the record. And I think if you don't, I think you should recuse yourself from this matter.
That request is denied. Please tell me what's inappropriate about what he's pleading no contest to.
Your Honor, again.
Civil rights.
Okay, hold on, Jeffrey. Your Honor, the fact of it is, he didn't admit that, Your Honor.
When you plead no contest, do you agree with me that when you plead no contest, the court is treating you as if you're guilty, Mr. Killawall?
Yes, Your Honor, it is, and you can read the police report, Your Honor, but you stated it on the record.
So what if I stated it on the record? So you're trying to tell me that a judge can't state on the record something that's in a police report?
Yes, Your Honor, some judges do that. But
That's not in the police report.
But Your Honor, I guess I'm going to lose this argument, but it's my contention. Again, had the witness been thoroughly investigated, Your Honor, there would have been no plea. So, Your Honor, I'll leave it to your discretion. You do what you want.
That's right.
Jeffrey, I don't need any comment from you.
Ms. Willenbring?
Thank you, Your Honor. My understanding was that we were here for a Ginther hearing, and what is stated in Mr. Killawall's motion and was just stated on the record are a lot of conclusory statements about what he believes Mr. Banis did or did not do when Mr. Banis is here and can possibly testify to that himself. My understanding is that Mr. Banis did personally visit Mr. Bloom in jail.
One
and
time.
also, I would ask that I not be interrupted by Mr. Bloom.
Mr. Bloom, you've made comments when I've been talking. Now you're interrupting the prosecutor. Seriously, I think you were held in contempt last time. Do you want another one?
I just want the truth and justice to be served, Your Honor, by not a biased judge.
So that's a yes, as I understand you to be saying, because you're going to keep having outbursts in court. Ms. Willenbring, you may proceed.
Thank you, Your Honor. I believe Mr. Banis will testify to meeting Mr. Bloom in person and to running a conflict check with Ms. Blaisdell and to not representing her in a case at that time, and also to discussing calling Ms. Blaisdell in Mr. Bloom's case, and then deciding not to call her because she would have in fact been inculpatory and not exculpatory. We have no information from the defense as to what Ms. Blaisdell would have testified to. No affidavit, she's not here, no information. And from what I have discussed and what I believe Mr. Banis will testify to, it was trial strategy to not call Ms. Blaisdell, which is not ineffective assistance of counsel. It's simply a trial strategy decision that he made along with his client. I do believe that Mr. Bloom is conflating being simply unhappy with what resulted from his plea, which was his bond being revoked in his felony case, with him being unhappy in this matter. Those are not equal comparisons, nor are they equal situations. Simply being unhappy with his plea is not a reason for him to withdraw this plea in the interest of justice. So I would ask that you deny this motion.
Your Honor, before you make a decision, I would ask if Mr. Banis would please take the stand so I could question him. It won't take long. I have maybe 10 questions to ask him.
Well, considering that we're here for a Ginther hearing, that was the whole reason for us setting it today, is to hold the actual hearing. But instead, we've been having the same arguments that we had last time. So at this point in time, if you're telling me you want to go forward with the hearing, that's what we're doing.
Yes, Your Honor.
And at this time, Mr. Bloom fully understands that once this hearing starts, he's waiving his rights to having any confidentiality with his attorney. Is that correct?
Can you explain that?
Well, your attorney needs to explain that, not me.
Your Honor, may I have a breakout room with my client?
Yes.
Thank you.
14B is back in session. We're back on the record in the Jeffrey Bloom matter.
Judge, I've had a chance to talk with Mr. Bloom. He understands that if Mr. Banis takes the stand under oath and discusses conversations he had with Mr. Bloom, that would normally be a breach of attorney-client privilege, but for this hearing only, Jeffrey understands the attorney can discuss any conversations he had with you. Do you understand that, Jeffrey?
Yes, sir.
Okay, thank you, Your Honor.
Great. This is your motion. So, Mr. Kilowell, I will swear in Mr. Banis, and then you may ask him questions, and then the prosecution has the opportunity to do the same thing.
Thank you.
All right. Mr. Banis, if you could please raise your right hand to be sworn, sir. You swear affirm to tell the truth, the whole truth, and nothing but the truth, and that the testimony you will provide will be truthful.
I do, Your Honor.
Thank you.
Thank you, Your Honor. Thank you. And Mr. Bloom, please no interruptions, no matter what you hear. Understand?
You don't have to say that.
Thank you. Mr. Banis, who do you work for?
Washtenaw County Office of Public Defender.
And at some point during your employment, were you appointed to represent a Jeffrey Bloom? Your Jeffrey Bloom?
Our office was appointed, and since I am the Assistant Public Defender assigned to the 14B court, I personally represented Mr. Bloom in the two cases relating to his mother, for which we're here today.
Okay, fair enough. And in your representation of Mr. Bloom, did you have contact with him?
Yes, I did.
And what type of contacts did you have with him?
I met with Mr. Bloom on various occasions throughout both cases at the jail.
No.
Mr. Bloom, please stop.
Met with Mr. Bloom at the jail. I recall speaking with him on the phone, calling from the jail, and in multiple breakout rooms throughout the proceedings.
Regarding your visits to the jail, how many would you say you had over the course of your representing Mr. Bloom?
I believe it was 2 times in person at the jail.
Okay. And at any point, did you ever send interns instead to discuss this matter with Mr. Bloom?
No, I did not. And if I could just add to that, trying to be helpful here. At that time, I had a law student intern who I had trained for upwards of a year. He was one of the best interns I ever had. He then, graduated and moved on. At no point did I ever send that intern to meet with Mr. Bloom. It is possible that someone else from our office, either an APD or an intern, represented Mr. Bloom at an arraignment, which is a separate division, either the arraignment on the original charges or an arraignment on a bench warrant.
Okay. Now you said you visited him 2 times, and do you think those were sufficient to thoroughly investigate the matter with Mr. Bloom?
Yes, I do. Combined with my other discussions with Mr. Bloom and my work, behind the scenes working on the case.
Okay. How long do you think each meeting went?
Boy, I don't recall the exact amount of time. I would say at least a half an hour each time at the jail, plus the other discussions I had with him.
You also mentioned that you had phone conversations with him. Was that initiated by Mr. Bloom?
Yes, calls from the jail telephones to our office, forwarded to me.
And how many phone calls would you say that you had with Mr. Bloom?
I believe it was 2.
Okay. And were there times when his phone calls were not answered, either by you or your staff?
I don't know.
Okay. Well, did you ever personally not accept any phone calls from Mr. Bloom?
No, I never would have. Well, okay, let me be clear. After he accepted the plea agreement and his bond was revoked in the felony case, he called me at one point, screaming at me, cursing at me, calling me names, blaming me for his bond being revoked. I believe at that point, we had made the decision that we had to file a motion to withdraw as his counsel. And so I think there was one call after that where he called and I decided not to talk to him because we were moving to withdraw or we had already moved to withdraw.
Was that after or before your plea discussions?
Oh, that was long after. After he accepted the plea agreement and after his bond was revoked in the unrelated felony case.
Okay. In your discussions with Mr. Bloom, did the name of Tiffany Blaisdell come up?
Yes, it did, for several reasons. She is obviously referenced in the police report. I discussed with Mr. Bloom trial strategy. It was my decision as his lawyer that not to call her as a witness at trial because based on the discovery, in my opinion, based on my experience, she had made, similar to what Ms. Willenbring is saying, made inculpatory statements, no exculpatory statements. But I think it's important to note that I did discuss with first of all, anyone who's referenced in a police report, whether it's a deputy, a complaining witness, or some third-party witness, they are all potential witnesses. Ms. Blaisdell was a potential witness. Mr. Bloom and I discussed that I was not going to call her as a witness at trial, and he agreed to that. At no point during my representation of Mr. Bloom did he ever disagree with me about not calling Ms. Blaisdell as a witness or tell me that he wanted her to be called as a witness. The first time I heard any complaints about that was after he accepted the plea agreement and after his bond was revoked in the felony case. It was after his bond was revoked in the felony case, which is the first time I heard any complaints about Mr. Bloom about trial strategy. Up until and through his acceptance of the plea agreement, he and I were on the same page and there were no trial strategy disputes.
Did you ever have any personal contact with her?
I did not call Ms. Blaisdell while I represented Mr. Bloom to ask her about what she allegedly stated in the police reports. The reason I didn't is because I didn't want to call her as a witness and Mr. Bloom didn't want to call her as a witness.
Were you representing her at the same time of this incident?
No, I was not. I represented her in an unrelated case up through her sentencing, which I believe was in August of 2021, which was prior to our appointment to represent Mr. Bloom.
At any point, did you feel that there was a possible conflict of interest in this matter?
No, I did not. I ran a conflict check. Our office has a conflict policy, which I followed. I can speak more about that. And then Now that this hearing was scheduled, I then went back and reviewed the Michigan Rules of Professional Conduct, and I believe there's also no conflict under those rules.
At any time, it sounds to me like you made a decision based on the police report. Would you now agree that possibly a phone call to Ms. Blaisdell would have either confirmed or helped you with your representation of Mr. Bloom?
No, I do not, because Mr. Bloom and I agreed that we should not call her as a witness. And yeah, because I did not think that it would be a good idea to call her as a witness because of the police report and because he and I agreed not to call her as a witness.
Did Mr. Bloom ever tell you that she was there during the incident? And I'm not talking about the drug matter, but she actually witnessed the what would be the charges against Mr. Bloom, and that you needed to contact her?
I believe she was present at the alleged incident based on the discovery and my conversations with Mr. Bloom. But I'm sorry, if you just asked, did he ever ask me to call her? The answer is no.
He never, and that was never your discussion. So you thoroughly discussed the matter of calling her or not calling her with Mr. Bloom?
I never discussed with Mr. Bloom calling her. I thoroughly discussed with Mr. Bloom whether she should be called as a witness or not.
Okay. In your experience as a public defender, do you always take what's said in a police report regarding what a witness statement is versus contacting a witness and getting a personal knowledge of what she may or may not have, or he or she may not have said in a police report?
I never assume that what's stated in a police report is true. In fact, I have a case where what's stated in the police report appears to be not true based on the body cam video. So no, I do not assume that what's stated in the police report is true.
Okay, not to belabor the point, but if that's true, why not contact Ms. Blaisdell and get her personal story from her? It's either confirm or confirm your suspicions of not to call her, or maybe she had a epiphany and you should call her.
I could have called her. I decided not to because Mr. Bloom and I agreed not to call her as a witness. And throughout the case, our primary concern was whether his mother was going to appear and testify and what she would say on the record. So she really was our primary focus. And in fact, on some body cam video, she had told the police that, or the deputies, that she was going to appear. So the reason I didn't call her is because Mr. Bloom and I never had any intention to call her as a witness. And a footnote to that is our focus really was on whether his mother was going to appear at trial and testify or not.
Okay, getting past that, just a few questions about the plea. Now, I've read the transcript and it sounds like you and Mr. Bloom thoroughly discussed that plea that he eventually put on the record, no contest plea.
Yes, I'm sorry. I've got clients calling me throughout the day. Yes, the transcript does not reflect. I noted in the transcript that it says it started somewhere around 3 p.m. It does not reflect that Mr. Bloom and I had at least 2 breakout rooms before that transcript commences. And I also had a breakout room with Ms. Willingbring to negotiate essentially a counter offer to the plea agreement prior to that transcript. And then you can see in the transcript later on, the court gave me and Mr. Bloom one more opportunity to have an additional breakout room to discuss the plea offer.
Were your meetings with Mr. Bloom in the breakout room, could you label it as contentious?
I would not contentious between him and I. His real focus was he very much wanted the prosecutor to agree that no new charges would arise out of the bond violation. That is something the prosecutor had already told me she wasn't going to do. I would describe probably every single one of my conversations with Mr. Bloom as he being verbally aggressive. Now, as an attorney, we just need to deal with that. And I cut through that. That didn't affect my representation of him. So I would not describe them as contentious as between him and I.
Just a couple more questions. Do you think he understood the no contest plea and the ramifications of that?
Yes, I do.
And you thoroughly discussed that with him and he willingly wanted to plead no contest?
Yes, I thoroughly discussed the plea agreement with him, that he wanted to plead no contest, and that we were prepared to go to trial. In fact, the trial actually started at one point, and then the court gave us another chance to have an additional breakout room.
I know you said Jeffrey can be a little aggressive, but were there any concerns from Jeffrey to you about your representation of him?
None whatsoever during my representation of him. The first time I heard any complaints from Mr. Bloom was after he took the plea agreement, what I believe was triggered by the fact that his bond was revoked in the felony case. It was when that bond was revoked was the first time I heard any complaints from Mr. Bloom about my representation of him. Prior to that, there was only one issue where it could remotely be described as a disagreement. Very early on in the case representing Mr. Bloom at the pretrial stage, he demanded that I get the case dismissed at pretrial based solely on the fact that he said his mother was never going to show up at trial. I told him that that's not going to happen. That's not how it works. But we said, this is the other case. We set it for bench trial and he was correct. She didn't show up at trial. And in fact, even though I was very confident the case would not be dismissed at the pretrial stage, I did follow up at Mr. Bloom's request. I sent an email to Ms. Willingbring in November asking basically if there was any chance the complaining witness was not interested in pursuing the charge. So the only issue that he and I ever disagreed on in any respect whatsoever was whether I could get the case dismissed at the pretrial stage, based on his assertion that his mother would not show up at trial.
You weren't the attorney on the felony case, correct?
That's correct.
And was that brought up that it was a possibility if he pled his bond, the bond would be raised in the felony matter?
He raised that issue earlier on in the case, around the pretrial stage. He called our office at one point asking about that. He and I discussed that. I advised him to speak with his felony attorney about that for several reasons. One, although I was aware of that felony case, I was aware of the charges, and I was aware that the complaining witness was not his mother in that case. The felony attorney, obviously, as I explained to Mr. Bloom, knows the circuit court judge better, kind of a know your judge issue, knows the prosecutor in the circuit court better, would be able to advise him on how the misdemeanor case could potentially affect his felony case. I recall telling him that maybe it could affect his sentencing guidelines, maybe it could affect his bond, but I certainly never told him it would have no effect on his felony case. That is absolutely not something I ever would do.
Okay, final question is just looking back at overall, would you have done anything different than you did?
No, I would not.
Thank you. I have no further questions.
I think Mr. Bloom is trying to talk, but he's muted and he may want to talk to you. Do you want to speak to him again before? And
Yes, Your Honor.
okay, we'll give you a brief breakout room.
Thank you.
Mr. Bloom, you'll have to call them in to unmute you. Mr. Killawall, you may now proceed.
Yeah, Your Honor, after discussing with my client, I would just ask if I could ask Mr. Banas just a couple more questions.
Yes, you may.
Thank you. Mr. Banas, you in your testimony, you said the trial actually began. I'd like to back up a little bit regarding your preparation for trial. And you can correct me if I'm wrong, but it's my understanding from the date the trial was set to the date the trial actually began was 7 days. And my two questions are, what preparation did you do with my client? And I would ask how many contacts you had with him between the date it was set and the actual date it began.
Preparation for trial included discussing with Mr. Bloom that if his mother would show up at trial, the trial strategy was she was lying and he would testify in his defense to that effect and that he did not assault his mother. I met with Mr. Bloom, I believe, one time. You know, we had already discussed the case prior to the trial. So I believe I met with Mr. Bloom only one time additionally to prepare for trial.
And do you think that was, you were properly prepared to go to trial on that matter?
Yes, I was absolutely prepared to go to trial.
Thank you. I have no further questions, Your Honor.
Thank you, Ms. Willenbring, your witness.
Thank you, Your Honor. Good afternoon, Mr. Banas. I just have a few just absolutely clarifying questions. As part of your conversations with Mr. Bloom, you agreed together not to call Ms. Blaisdell as a witness. Is that right?
That's correct.
And as for the plea offer that was made to Mr. Bloom, you were present when that was discussed on the record. Is that right?
Yes, I was.
And you also discussed the plea offer with him in at least 2 breakout rooms. Is that correct?
Yes. Actually, I think it was 3 breakout rooms. And also you and I had a private breakout room where I was trying to negotiate a counteroffer, trying to convince you to agree not to bring additional charges based on the bond violation. So yes, I discussed the plea offer with Mr. Bloom multiple times and also with you.
And did you discuss the rights that he would be giving up if he entered into a plea?
Not in detail in the way the judge did, as is typical in any case, but absolutely in terms of that we would not be doing the trial. He would be giving up the right to have the trial, call witnesses, etc.
And did you ever discuss Mr. Bloom's qualms with Ms. Blaisdell outside of the case for which he was going to trial on that day?
I'm sorry, discuss his what?
His issues with Ms. Blaisdell outside of the ones discussing her presence at the scene in this case?
He made some statements that I saw in the transcript, which I had never heard before. What he and I discussed was that we would not be calling her as a witness.
Okay. And you were present in the courtroom with Mr. Bloom when Judge Washington read his rights and the rights that he would be giving up by entering into the plea. Is that correct?
Yes, I was. I did not see anything in the transcript that, other than maybe 1 or 2 typos, which are very obvious, anything that seemed incorrect.
I have no further questions for this witness, Your Honor. Thank you.
Thank you very much.
I have no follow-up questions, Your Honor.
Thank you very much. All right. Mr. Banis, thank you for being present today and testifying. We appreciate it.
Thank you, Your Honor.
Mr. Kilowall, do you have any other witnesses that you would like to call at this time?
No, Your Honor. No.
All right. Mr. Bloom is trying to communicate with you again, it seems to me.
Your Honor, I thought he and I discussed this, but can I have another breakout room, Your Honor?
Mr. Bloom, are you trying to communicate with the attorney, sir?
I would just like your bar number, that's all.
What, Jeffrey?
He wants my
It's-
bar number.
Yeah, that's all.
Jeffrey, this is not the time.
It's all good.
So, Mr. Kilowall, you have no further witnesses, is that correct?
No, Your Honor.
All right. Ms. Willenbring, do you have any witnesses that you need to call at this time?
I do not, Your Honor.
Thank you. Mr. Kilowall, would you like to make any further argument at this time?
Your Honor, you've heard my argument several times. You've heard the testimony. I will leave it to the court's discretion. I would just say that I believe Mr. Bloom feels he wasn't properly represented by Mr. Banis, and there's no reflection on him as an attorney. But that being said, advocating on behalf of my client, I would ask you to please consider the testimony you heard and make the proper decision, Your Honor.
Thank you. Ms. Willenbring?
Your Honor, Mr. Banis's testimony was very clear. He met with Mr. Bloom. He discussed the witness at issue, Ms. Blaisdell, and they agreed as a strategy. And no matter how many times Mr. Bloom denies it, Mr. Banis just testified under oath to these matters. And he is an officer of the court also as an attorney. He met with Mr. Bloom multiple times. They discussed Ms. Blaisdell and they decided not to call her as a strategy. Mr. Bloom's feeling he wasn't properly represented does not meet the legal standard required here, both to either show that Mr. Banis was ineffective or to show that Mr. Bloom should be able to withdraw his plea. Mr. Bloom's unhappiness with Mr. Banis, in fact, came, as Mr. Banis testified, after Mr. Bloom took the plea and his bond was subsequently revoked in his felony matter. I really don't think that this has anything to do with his unhappiness with the plea and what happened, but his unhappiness that his bond was revoked in a separate matter based on a intelligent and knowing plea in this case. Again, Mr. Banis's testimony was clear about what happened here, and I'd ask that you deny the defendant's motion.
Thank you. I have I've read, first of all, Mr. Kilowall's motion very closely, which is why we ended up in the position we're in right now to having a Ginther hearing when he raised the concerns regarding Ms. Blaisdell. And I've reviewed the transcript in this particular case. And as to the transcript, I see that I did advise over and over again Mr. Bloom of his rights with respect to this particular case. And he said he understood his rights. In fact, at one point, he even says on page 9 that he's willing to do 93 days if they will just tell me that they will not bring up new charges for either talking on the phone. Because if I did talk on the phone, I have no money on my phone. Charges have to be accepted with a credit card. So he clearly understood what his rights were at that point in time. With respect to counsel's request that I recuse myself after someone has pled to a charge, I find that insulting. And I just don't even understand why that was brought up today. Mr. Bloom continues to try to talk over the court, but he is muted just so that the record is clear. And in fact, his behavior is going to get him some additional time that will be stacked on whatever else he has going on. I've given him ample opportunity to break out with his counsel as many times as he needs to, just like I did on the date of this particular hearing. And I agree with the prosecution that there is simply no explanation for what happened in this case, other than the fact that once he actually pled to this offense and he was violated on his felony, which then required that he spend an additional amount of time in jail that he had not anticipated, he had buyer's remorse for entering into this plea. With respect to the Tiffany Blaisdell matter, Mr. Banis has testified, first of all, that he met with Mr. Bloom an adequate number of times in order to go over this with him. In addition to that, I gave Mr. Bloom 3 breakout rooms on the date of hearing when we had a witness present to testify on that particular date so that he could decide whether or not he wanted to proceed with trial. Mr. Banis met with him, met with the prosecution, and went over all of these rights as I did. And we had this, at the time of the plea itself, we were on the record for over an hour trying to get the plea accomplished because Mr. Bloom kept interrupting. Mr. Bloom at the same time kept wanting to explain things to me, and I listened to all of that. And he fully understood and entered into a no contest plea, which means he's going to be treated as if he's guilty. And Mr. Banis' statement that when he did his conflict check, he found that there was no conflict under their policy, and the conflict that he checked it against the state of Michigan's conflict rules, and there is no conflict against the rules of the state of Michigan. So therefore, he did not find that there was a conflict. And when he discussed this matter with Mr. Bloom, which Mr. Bloom has been given ample opportunity to testify here today too, and he has not done so, the actual situation is this. Mr. Bloom and his counsel discussed whether or not Ms. Blaisdell would be in his best interest to call, and she was not. And so they made that as a choice because as it appears to me, it appears that they were concerned that she was going to have inculpatory statements to make, not exculpatory. So as a result, I find that there was no ineffective assistance of counsel and that he was provided with reasonable opportunity to discuss with his counsel, and his counsel properly represented him in this matter. Are you prepared for sentencing today?
Yes, Your Honor. Your Honor, and yes.
Have you reviewed the report with your client?
Yes, Your Honor.
Are there any corrections, additions, or deletions?
Not that I'm aware of, Your Honor. Other than his name seems to be misspelled. It's the same case in the circuit court matter, but it's Jefffery.
I see counsel in a breakout room, please. All right, Mr. Kilowall, I'll give you a breakout room with your client.
Thank you very much, Your Honor.
You're back on the record in the Bloom matter. Are you ready to proceed?
Thank you, Your Honor. Your Honor, I've had a chance to speak with Mr. Bloom. He understands Your Honor is going to give him credit for time served. I advised him he has a right to allocute in this matter. but it would be my advice to him that he not, and we get on with his sentencing and we move forward on this matter. Is that my advice to you, Mr. Bloom?
That was your advice, but I don't wish to take your advice.
Okay, well, I guess we're going to do sentencing then.
Yes.
All right, Mr. Bloom, it is your opportunity to allocute. I presume your attorney has spoken to you about whether or not you can be held in contempt and explain what consecutive sentences are. Is that correct?
Yes, ma'am, I'm fully aware.
All right, thank you.
I don't mean to disrespect. I don't mean to disrespect. I don't mean to, if you even get a hint that I'm being disrespectful to your honor, just wave your finger at me like a naughty boy and I'll stop. I would just like to say that back in December, you offered me, you said just plead and I will give you time served and it's all over with. But I wish to, I didn't assault my mother, your honor. And my mother, okay, we'll leave all that alone. It's already done. I guess it's already done. But I just want you to know that I made you aware in December. I said, your honor, Miss Blaisdell that was in this case. Anyway, the prosecutor was trying to bring up like me and Miss Blaisdell had some kind of qualm, she said. There's never been a problem between Miss Blaisdell. For the entire time I've known her, we've always gotten along. Anyway, I made you aware in December. I said, your honor, I wouldn't have a problem pleading guilty to this case if you would take it upon yourself to we could go on about this a long time. I talked to Mr. Ted Heaton, her probation officer, for 2 hours, and it wasn't about me, it was about her. He wasn't even supposed to disclose information that he did, but he did because he knew what I knew, okay? I don't want you, I think you can read between the lines. I think you're a wise Black woman that can read between the lines with situations that I'm, okay. Anyway, I told you I would plead guilty back in December if you would get Miss Blaisdell a new probation officer that would make her take random urine drops and not let her be known and not excuse her from court from using that she did in your court. She was excused several times by Mr. Heaton because she had used drugs for days and couldn't appear in the right frame of mind, okay? Now, you sentenced Miss Blaisdell on the 7th, I think it was, of this month, to 30 days because she violated her probation or whatever. But, she came in jail, your honor, and I asked you back then to get her some help. And I said, I wrote Lansing, I wrote everybody saying, just get this girl some help because she needed help. But anyways, it's all over with now. She ain't got to worry about it now. But your honor, I'd just like you to know that maybe in the future, you could be aware or try to be a little more aware when somebody needs some help, because Miss Blaisdell was since 4 months ago when I seen her, she's lost over 50 pounds, okay? She's got sores all over her face, her lips. She looks older than me, your honor, and I'm almost 60 and she's like 45. But I just want to let you know that back in December, I asked you this, and and I just would like you to be made aware of what might be going on behind the scenes of your, and all I wanted was her to get some help. And I said I would plead guilty, and maybe from now on, she's through now. I mean, it's done now. She ain't got to worry about it. She can go out and get high and kill herself or whatever she's going to do, but I hope that don't happen because, I would see that I would feel myself that it was partly due to the justice system not giving her a fair shake. Okay. That she was just like I wasn't given a fair shake and Mr. Bannis lied. But anyway, regardless of all that, you were going to give me time served anyway. And I can't get no more than 93 days and whatever, but and that isn't what matters to me, your honor. What matters to me is when the very first case of this came around, I said, your honor, I believe you are a knowledgeable, very intelligent woman. Okay. And I still believe that. I just believe that in some incidences, like this being with my mother, okay, and there being several cases with my mother that it even came before you involving me and my mother that have been dismissed because, like I said before, there are many things that are relevant to this case that seem irrelevant, but this isn't family court and this isn't family therapy and this isn't, I understand all that. But the point of it being, Your Honor, thank you. Please, 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 in the future, maybe be a little more aware when people are losing a lot of weight and getting sores and not showing up for court and not getting random urine drops like they're supposed to, and that maybe something's going on, that they might be needing help, and I'd just like to say thank you, Your Honor. Thank you. Have a great day.
Thank you, Mr. Bloom.
You're welcome.
I cannot speak with you on anybody else's case, but I will say this, sir. I listened to every word you said here, okay? It's the sentence of the court that you serve 93 days, credit for 93 days, sir. Mr. Bloom, I truly wish you the best.
Thank you.
And
Let's wish Tiffany the best too.
thank you, sir.
Thank you.
All right,
Goodbye.
bye.
Thank you, Your Honor, for your consideration of this matter. Jeffrey, I'll be back to the jail one of these nights on the circuit court matter.
Thank you, sir.
Thank you.
Thank you, Ms. Willenbrough.
That concludes our court.
Thank you, Your Honor.
Thank you, Your Honor.
Continue, Ms. Willenbring.
Mary, I
Good
need
to see you
last
as well, Your Honor.
7 attorney visit.